At the conclusion of this lecture, you will have a general understanding of what is meant by contract, understand the notions of offer, acceptance, and invitation to treat, and be able to explain what is meant by acceptance and its consequences. A contract under English law is an agreement which gives rise to obligations that can be enforced or recognized by law. Under common law, there are requirements for the creation of a contract to be legally valid. These are agreement, contractual intention, and consideration. The first requirement is that the parties should have reached an agreement. Generally speaking, an agreement is reached when one party makes an offer, which is accepted by another party. In deciding whether the parties have reached agreement, the courts will apply an objective test. An offer is an expression of willingness to contract on certain terms. It must be made with the intention that it will become binding upon acceptance. There must be no further negotiations or discussions required. For further understanding on this issue, see the following cases: Stover v. Manchester City Council, 1974, and Moran v. University College Salford, 1993. The person who makes the offer is the offeror. The person who receives the offer is the offeree. The offerer will be bound if his or her words or conduct induces a reasonable third-party observer to believe that he or she intends to be bound by such representations, even if in fact he or she has no such intention. An offer can be addressed to a single person, to a specified group of persons, or to the world at large. An example of the latter would be a reward poster for the return of a lost pet. An offer may be made expressly by words or by conduct. An offer may be revoked at any time before its acceptance. However, the revocation must be communicated to the offeree. A unilateral offer is one where one party promises something in return for some action on the part of another party. In relation to unilateral offers, revocation is not permissible once the offeree has started performing the task requested. Reward cases are examples of such unilateral promises. Under bilateral contracts, each party undertakes to the other party to do or to refrain from doing something, and in the event of his or her failure to perform his or her undertaking, the law provides the other party with a remedy. It is important to understand that not all offers are legally enforceable. We will now examine the various methods of communications in order to determine whether an offer is legally enforceable. A statement of intention does not create a legally enforceable offer and contract. Here, one party states that he intends to do something. This differs from an offer in that he is not stating he will do something. The case of Harris v. Nickerson, 1873, illustrates this point. Here, the auctioneer's advertisement was a statement that he intended to sell certain items. It was not an offer that he would sell the items. In the supply of information, no offer is made, nor is a contract formed. Here, one party provides information to another party. He supplies the information to enlighten the other party. The statement is not intended to be acted upon. See the case of Harvey v. Facey for more information. In this case, one party telegraphed, in response to the query of the other, what the lowest price was that he would accept for his property. An offer must be distinguished from an invitation to treat, by which a person does not make an offer, but invites another party to do so. Whether a statement is an offer or an invitation to treat depends on the intention with which it is made. An invitation to treat is not made with the intention that it is to be binding as soon as the person to whom it is addressed to communicates his acceptance to its terms. Common examples of invitations to treat include advertisements or the display of goods. A very famous case on the issue of invitation to treat is Carlyle v. Carbolic Smokeball Company. Here, a medical firm advertised that its new drug, a carbolic smoke ball, would cure flu. And if it did not, buyers would receive £100. When sued, Carbolic argued that the advertisement was not to be taken as a legally binding offer. It was merely an invitation to treat, a mere advertisement puff. However, the Court of Appeal held that the advertisement was an offer. An intention to be bound could be inferred from the statement that the advertisers had deposited £1,000 in their bank to highlight Carbolic's sincerity. There are numerous examples of representations where the courts have held that communication does not amount to an offer, but is merely a form of invitation to treat. Most advertisements are considered invitations to treat, but some may be regarded as offers depending on the language used in the advertisement. Advertisements in catalogues provide information about items for sale or services provided, and their prices are regarded as invitations to treat. If it were regarded as an offer, and the manufacturer ran out of the product or was not able to provide the service, they would then be found in breach of contract for anyone who accepted such an offer. A share prospectus is merely an invitation to treat, inviting people to make offers to subscribe for shares in a company. Display of goods in a shop window is regarded as an invitation to treat. The classic case in this area is Fisher v. Bell, in which a shopkeeper was prosecuted for offering offensive weapons for sale by having flick knives on display in his window. It was held that the shopkeeper was not guilty, as the display in the shop window was not on offer for sale, but only an invitation to treat. The display of goods on the shelf of a self-service shop is also seen as an invitation to treat. The relevant case here is of Great Britain v. Boots Cash Chemists in 1953. The defendants were charged with breaking a law which provided that certain drugs could only be sold under the supervision of a qualified pharmacist. They had placed the drugs on open display in their self-service store. The display of goods on the shelf was only an invitation to treat. In law, the customer offered to buy the goods at the cash desk where the pharmacist was stationed. A request for tenders is an invitation to treat, and the tender is the offer. See the case of Harvela Investments Limited versus Royal Trust Company of Canada Limited for a practical legal example. Note, however, that the invitation to treat may contain an implied undertaking to consider all conforming tenders, as was held in Blackpool and Flyde Aero Club Limited versus Blackpool Borough Council. The advertisement of an auction is considered an invitation to treat on the part of the auctioneer. The auctioneer may withdraw items from the auction or cancel the auction altogether without incurring any liability from potential bidders. The bid is an offer. When the auctioneer brings his hammer down, he has accepted the offer. For auctions without a reserve price, the auctioneer enters into a collateral or separate contract. The nature of the collateral contract is that the auctioneer will accept the highest bid. See the case of Warlow v. Harrison. In terms of auctions with a reserve price, each bid represents an offer which the auctioneer may reject or accept. Acceptance of an offer occurs and an agreement is formed when the auctioneer knocks down on the hammer after the reserve price has been met by a successful bidder. As the agreement is not formed until the hammer is knocked, the bidder can withdraw a bid before this time. See the case of Payne v. Cave. To be effective, an offer must be communicated. There can be no acceptance of the offer without knowledge of the offer. An offer must be accepted in accordance with its precise terms if it is to form an agreement. An offer becomes effective once it is communicated to the offeree. The acceptance can be by words or by conduct. See the case of Brogden v. Metropolitan Railway Company, where the offeree accepted the offer by performance. Acceptance has no legal effect until it is communicated to the offerer. The general rule is that a postal acceptance takes effect when the letter of acceptance is posted, even if the letter may be lost, delayed, or destroyed. This is known as the postal rule. See the case of Henthorne v. Fraser. However, the postal rule will not apply if it is excluded by the express terms of the offer. It is important to note that an offeror cannot stipulate that the offeree's silence amounts to acceptance. If the offeree attempts to add new terms when accepting, this is a counter-offer and not an acceptance. A counter-offer implies a rejection of the original offer, which is thereby destroyed and cannot subsequently be accepted. See Hyde versus Wrench. In some cases, the parties will attempt to contract on standard forms. In this instance, there will be a battle of the forms, with offers and counter-offers passing to and fro. The courts have held that the last shot wins this battle of the forms. A counter-offer must not be confused with a request for information. Such a request does not end the offer, which can still be accepted after the new information has been given. In conclusion, you should be aware that the components must be present for a contract to be valid. These are offer, agreement, and consideration. The difference between offer and invitation to treat is that an offer intends to create legal rights. An offer must be communicated, and revocation must be communicated before acceptance. Auctions, tenders, goods in shop windows, goods in display, and catalogue advertisements are usually invitations to treat. An offer must be